Hello, everybody. Good morning. Coming in. That's really great that you're here with us, and especially you're welcome to people who are joining us for the first time. I'll explain in a couple of minutes how today's session is going to work. If you're back with us, you came along to the last session, it's really nice to have you here as well, and we must have done something right, so it's really good to see you. Thank you. I think that's everybody coming in. First of all, I'm going to introduce myself. My name's Tracy Francis, and I work for ARC Scotland. We manage the Scottish Transitions Forum. And this seminar is the second in our series that's Transitions Planning in Extraordinary Times. And we did this because we felt that there are so many situations that parents and carers are finding themselves in at the moment, with young people leaving school, not quite sure of the options. Because of the situation around COVID and the pandemic, it's not always clear how you go about planning, what you can do, and what as parents and carers you can do to prepare. So this series is designed to plug some of those gaps, hopefully, and to give you the chance to connect with some of the leading organisations and practitioners in Scotland to ask questions and to get some of the answers that you need to be able to plan for your young person and your person's next steps. So one of the biggest challenges, I think, as a parent is working out how you can support somebody who really needs support once they've become an adult, in the eyes of the law and in everybody else's eyes as well, and going on giving them the support and the help that they need. So today's topic that we're focusing on is looking at some of the ways that you can do that as a parent, and we're focusing particularly on guardianship and power of attorney. And I'm really pleased to say that we've got with us Nicola Smith, who's from Cairn Legal in Glasgow. And Nicola, I'm just going to ask you to say a couple of words about yourself and the work that you do.
No problem, thanks Tracy. My name's Nicola. I'm a solicitor, and since 2002 I've been specialising in the law and individuals who have capacity issues. So we assist mostly parents who need to be making decisions for their children, and we also help people who have capacity issues for other reasons, so where there's been a brain injury or mental health issue or something like dementia or Alzheimer's.
That's great, thanks Nicola. Okay, just a bit of housekeeping before we get started. If you were here last week, you'll know how it ran. I'll just do a bit of a recap. On your screen somewhere, you should have either a wee icon that's a question mark or maybe the word questions. And you can put your questions or make comments throughout the session as we go along. And I'll keep an eye on those, and I'll be passing those on to Nicola during the course of the next hour or so, and we'll try and make sure that as many questions as possible are answered. The other thing that you could try doing is we've also got some handouts. You should have an icon or a word on your screen somewhere that says handouts, and if you go into that, then we've got 5 handouts for you there. There's the slides that Nicola is going to be talking about. There's also a couple of fact sheets from Cairn Legal about different aspects of guardianship, power of attorney, and involvement in education. And there's also our transition planning for parents guide that's got lots of links for different organisations that can help you with different aspects of transitions and transitions planning, especially at this time with COVID and the situation that we're in. I am going to ask, we are recording this session, and the session will be available later, so if you have any problems with sound or anything like that during the course of the recording, don't worry about it. We will be able to get you this later, and you'll still have the information. I'll send you the links and so on after the session. But the other thing to say is that at the moment, if you should also have an icon of a little hand somewhere on your screen. And if you click on that, you can raise your hand to, if you've got an experience that you'd like to share, or if you want to speak directly to Nicola rather than type in your question, you can do that as well. We won't be able to take everybody, I don't think, because of time, but that's another way that you can interact today if you want to. So I'm just going to say, I hope you've got a cup of tea or something like that to hand. And I'm going to hand over to Nicola, and Nicola's going to start off talking us through guardianship and the main things that you need to think about in relation to that. Nicola, I'm going to make you the presenter and then you can share your screen when you're ready, okay? Just a second. There we go.
Great, thank you. I'm going to talk about guardianship and powers of attorney today, and hopefully give you enough information to let you decide if this is something that you maybe need to think about for your own family. We'll start with guardianship. I'll take you through the process and give you an overview, and then we'll pause and you have the opportunity to ask some questions before we move on to talking about powers of attorney. What I'm going to do is kind of take you through the process of becoming a guardian, what's involved and what happens afterwards. It's really just a guide, and I don't want you to even try to remember everything or work out everything. The main thing for you to do today is to identify, is this something that I need some more advice about? And if you do, then you'll be able to get that. The process of becoming a guardian at the best of times takes about 6 to 9 months. There's long periods in that when not very much happens. So sometimes you are basically on a waiting list for a report, or your paperwork might be with the court waiting for a court date. So during that period you have pockets of time when quite a lot happens and you have to possibly attend meetings or arrange meetings, and then you'll have long periods of time where really you're not hearing anything. It's taken longer just now, I suppose for obvious reasons. Many of the courts and local authorities have not processed routine guardianship applications over the last few months, and so we've got a bit of a backlog which will take time to clear. So I suspect you're going to be looking at possibly up to a year in a lot of areas, from first contacting a solicitor to actually being appointed as guardian. Your solicitor will ask you a lot of questions, do a lot of the work and make most of the arrangements for you. So when I talk about the process today, it can seem like there's a lot involved, but there's not. You don't need to worry about things like contacting doctors, arranging appointments, notifying the council. We would do that for you. And I would liken it to something like buying a house. You rely on your lawyer when you buy a house to check the title deeds, negotiate what's there, make sure you're buying what you think you're actually buying. And in the same way, your lawyer's going to make sure that you have the right paperwork at the right time and the right powers to be a guardian. So it's great to have a good idea of what's involved. It's good that you can then ask your solicitor the right questions and make sure that you have somebody who's experienced and knows what's involved in the process, but at the same time don't feel that you have to learn everything about it, because you'll be guided through it. I'm going to start with why you need to think about guardianship. So in Scotland, until your child is 16, you have what's called parental rights and responsibilities. So where you've got a child with a significant capacity issue, it means as a parent you can make decisions for them. So if they need medical care, if there are decisions about where they go to school, what care they receive, what respite they have, dealing with any income that they have, perhaps from PIP, then you're able just to do that as mum or dad. When they reach the age of 16, the law, for the vast majority of purposes, says they're now an adult, and so your parental rights and responsibilities stop. And that means for most people it's not a massive problem, because the child would just make their own decisions at that point. But where you've got a child where that's not an option, where they're not able to make their own decisions, then you have to think about guardianship. And that's a process that you go through essentially to continue to be able to make decisions for the person when they're over the age of 16. You can apply to be a guardian before someone gets to the age of 16, so you would have it in place for the 16th birthday. So we normally recommend that parents come and see us sometimes shortly after their child's 15th birthday. And that just allows us to get paperwork in place, to get in the queues for the reports that we need, and if possible, to have the guardianship order starting fairly close to the 16th birthday. But please don't worry if your child is over the age of 16. In most cases, nothing particularly changes from the day before the 16th birthday to the day after. It doesn't generally create any problems. But that said, there's likely to be a time at some point in the future where you will need to be the guardian. So it might be when you're going through transition and moving to adult services, you might want to manage a self-directed support budget. You're maybe looking at the person moving into supported accommodation or independent living, and tenancy agreements need to be signed. And you might have concerns about medical treatment. So we recommend, because it's not something that happens very quickly, don't wait until you need it. Once you become aware that guardianship might be something that's useful for your family, get some advice and start the ball rolling with getting it into place. It tends to come up as an issue at times of transition. So when someone is maybe leaving home or leaving school or moving to adult services, we probably have around 60 or 70 guardianship applications at any one time, and those are for a huge range of ages. So for some people, it's never really come up as an issue until the person is maybe 35, 40, 45, sometimes even older, and it's only at that point there's a change in their life and mum and dad have been asked, do you have guardianship? This is something you might need. But ideally, think about it early. It means you're not worrying about it in a time of crisis, and if and when you need the paperwork, it's there. In terms of who can be the guardian, when we're talking about people with learning disabilities, the most common guardians are mum and dad. Guardianship applies to other groups as well, so bear that in mind. Sometimes I'm going to talk today about your child because I think that's a category that most people attending fall into, but it could be someone else that you want to make decisions for where you have a different relationship. So guardians can also be stepchildren. It could be for your niece, your nephew, for a foster child, for a brother, for a sister. So it could be for a whole range of people. So when I talk about your child, you can substitute whatever your particular family relationship is in there. So normally it's mum and dad, or mum or dad, where there's only one parent that's been involved. The most common scenario for us is where you'll have what's called joint guardians. So you'll name two people to be able to make decisions for someone. You can also have substitute guardians. So that means that you get appointed as the guardian, but you name someone else to step in if you aren't able to fulfill that role. So essentially it's a substitute, it's a backup role. So it's very common for mum and dad to be appointed perhaps as joint guardians and name another child as the substitute guardian who will at some point step into that role. For some people, they don't have an obvious person who can be joint guardian or substitute guardian. That's fine, you can be appointed on your own. Some people will have a joint or substitute guardian that's not a family member. It might be a close family friend. And again, that's absolutely fine. There are some restrictions on who can be the guardian. So your solicitor will ask you some questions about your own personal background. So the sorts of things that can be an issue are where you've perhaps had financial issues in the past, so you've been made bankrupt, or where you've got criminal convictions, particularly for things like fraud or anything to do with finances or theft. It doesn't prohibit you being a guardian if you do have criminal convictions. Obviously, we would just look at the circumstances of the particular case. So lots of people have historic, fairly minor convictions, and we need to know about them, but it's not necessarily going to be an issue in becoming a guardian. In terms of the types of powers you would have, so the types of decisions you would make, we tend to talk about financial guardianship and welfare guardianship. So financial powers are obviously about managing money for someone, managing any property they might own, looking after benefits, and then welfare powers are about the care somebody gets, the education they get, the medical treatment they get. Most clients we deal with need both, so they'll need fairly full welfare powers to make decisions about things like medical treatment and care, and they'll need some limited financial powers. For most families, the person will have just benefit income and is unlikely to have substantial savings or resources or own property, so they won't need a long list of financial powers, but they will need powers to manage the financial aspects of care, so self-directed support, direct payments, etc. The solicitor, first of all, will ask you a lot of questions and be able to frame the sorts of powers that you need for your own situation. So I know what we do is start with a fairly standard style, which lists a lot of different powers, and then we add or take away just depending on what a particular person needs. And I'll come on and talk to you about some of the specific powers that we might need to discuss with you just towards the end of this section. Guardianship is a court application, so you do really need a solicitor to help you with it. I think there is some guidance about doing it on your own, but I would suggest it's much easier to do it through a solicitor. And for most, I'll talk about legal aid as well a little bit later, but that will cover most of the costs of the application. So there should be little or no cost to you in employing a solicitor to do the work for you. The solicitor will check with you the powers that you need, get some background about your family member, and then arrange 3 reports. And what goes to court are these 3 reports and the application itself. 2 of the reports are medical reports. One, a minimum of 1 has to be from a psychiatrist. Sometimes the second report will be from your general practitioner, or sometimes we'll use a second psychiatrist, just depending on what's appropriate in the circumstances. The third report is from a mental health officer, which, for those of you who don't know, is a specialist social worker who's had additional training in completing these reports. The medical reports are very easy to get. We have a list of psychiatrists that we use a lot who will come to your house in normal times at a time that suits you, so an evening or a weekend, and meet with you and prepare the report, and we can arrange those quite quickly. Where we tend to have the longest delay is getting that specialist social worker appointed to the case, because there's a long waiting list and it can take certainly several weeks, if not months, to have somebody appointed. So we would get you in the queue for a mental health officer, and once they were appointed, start to think about the medical reports, because we can arrange those very quickly. Before the various coronavirus restrictions were put in place, people would meet face to face in order to produce these reports. We're doing it in different ways now, so the courts are generally accepting assessments that we do through some sort of combination of phone call and video call. I don't know what will happen in future, whether that's something that's going to continue or not, but certainly just now there's nothing to stop you progressing things, even if you're shielding or you're vulnerable or you have a family member that's shielding. Normally we're still able to progress things and get the reports from a distance for you. There will be some restrictions on that, so where someone's capacity is not clear, where they may be on many levels functioning highly, and it's much more difficult to assess if they need a guardian or not, then we might need to look at face-to-face meetings. And also if your case is in any way contested or controversial, if it's likely to be opposed, then there might be a need for face-to-face meetings, but hopefully we can do most things electronically. Once we've got the reports, we let you see them and it all goes off to court, and the sheriff will check the paperwork looks in order and send it back with a date for a hearing. The date for the hearing's usually another 4 to 5 weeks from the date we submit it to court. Obviously at the moment it's been a little bit longer than that. And interested parties get copies of the information. So for example, if you are applying, if you're a mum and you're applying to be guardian for your son, and your son attends perhaps a day service or is in school and has dad doesn't live with you but is involved, then paperwork notification of the application would go to dad in the day centre or school or care provider. And that's just because we assume the person is not going to have the ability to possibly contact a solicitor, get advice, oppose it, agree with it. It's important that anybody who might have information about whether or not this application is appropriate is given the chance to comment on it. On the date of the hearing is usually a bit of a non-event, in honesty. Again, until recently, clients were very welcome to come along. An average hearing probably takes about 90 seconds because the sheriff has these reports, has the application and has read them in advance. So it's very much just that you're having it called in court as a formality and the application gets granted. Just now we're trying to reduce the number of people going to court, so the client's still very welcome to come, but obviously unless there's a good reason to be there, then it might be advisable not to come along at the moment. It's a closed court, which means that the only people there would be your lawyer, the sheriff and the sheriff clerk and yourself, so people can't come in and observe it or watch it. And it's done relatively informally, so we don't wear the gowns and wigs that you would normally wear in court. The sheriff will sit on the bench, but they don't have gowns and wigs on, so they try and make it as friendly as possible. After the court date, assuming you've been appointed, then you would probably about a week later get an official order through the post that would say you're the guardian. Normally, what we're thinking about somebody younger, the courts will say, we got to look at this again in 3 years or 5 years. Occasionally they'll grant it for 10 years, but for a young person now, it's pretty much unheard of for you to have an order that would last for the duration of somebody's life. It's always going to need to be renewed at some point, usually every 3, 5 or 10 years. Just depending on particular circumstances. When you get the order, it's not over as such until the renewal date, whenever that is. There are supposed to be people monitoring to make sure that you are exercising your powers as guardian in an appropriate way and making good decisions for someone. The reality is, for most people, there is very little by way of ongoing monitoring. Sometimes the public guardian will ask you to submit annual accounts. It depends on whether there's anything complicated about the person's finances. Social work should meet you once a year for a formal guardianship review. Again, I get very mixed feedback from clients about whether that actually happens in practice. So you may not hear a huge amount, but you would be expected to keep some records about decisions. So particularly if you're managing money, to keep bank statements, and if you make any major purchases or any major decisions, for example, if someone got an inheritance and you had to deal with that, you'd be expected to notify your lawyer and the public guardian and get some advice about what you would need. What I've described as a straightforward case, you'll probably know whether your case is going to fit into that category or not. I would say the vast majority of cases we deal with are straightforward, and it's essentially an administrative procedure whereby you go to a solicitor, you get reports, you put it to court, people are told about it, and you get appointed. We are increasingly seeing opposed guardianships where possibly not so much where it's a parent that's the applicant, but where you have family disputes, for example, so parents are not in agreement about what the best decisions for the son or daughter are. It can become contested. Occasionally we'll come across cases where the local authority have some concerns about decisions that have been made and they get involved in the proceedings. So we'll usually know at an early stage whether it's likely to be contested or not. If it is, then it's a longer process, and obviously we could talk you through it if that applies. The renewal, people can get quite frustrated about the idea they'll have to renew the guardianship. It can be quite a good thing because it gives you a chance to look at whether or not the powers are appropriate. And it might be that at the renewal stage, it's a good idea to appoint someone else as a substitute. So, for example, another child might be 15 when you originally become guardian, but at the age of 25 or 35, you then think it's appropriate to name them as a substitute. It's also an opportunity to look at the powers. So as I said at the start, we have a list of I guess, standard powers that you will see in most guardianships. We also ask you questions about other powers that you may or may not need. Going back 10 years, it would have been rare for us to ask these questions, but experience has shown that in some cases we've had to go back to court to ask for changes. So we ask these questions at the outset. So sorts of things your solicitor should be asking you about and you should be thinking about are whether or not you need any powers of restraint. Restraint sounds like a big thing, and most people wouldn't see themselves as having to physically restrain their children, but it covers a lot of things that wouldn't necessarily spring to mind. So if someone's a wheelchair user and they have to have ankle grippers, for example, or something to keep them in the wheelchair, sometimes that'll be classified as a form of restraint. Where they need a harness, so if they're not safe travelling in a vehicle and have been undoing seat belts, we've got lots of cases where somebody has needed to be fitted with a harness, and again that might need a specific power. I've even had cases where clients have been to brush someone's teeth, for example, or to cut nails, rather than restrain, I would call it as apply light pressure to keep someone's hands down while they carry out basic hygiene measures. But when that parent's then asked paid care staff to do the same, the staff haven't been able to do it because that's classified as a form of restraint and needs a specific power. So we may ask some of these questions, and that's why, to make sure you have what you need. Other things that would fall into that category that aren't necessarily standard are powers of seclusion. So if someone has to be removed from a situation into a safe space, for example, and a door would be shut then that would be classed as seclusion or a liberty deprivation. We put that in. I had cases recently where we had to restrict people's access to social media because they're sending inappropriate images or forming inappropriate relationships. So that would be an extra power. Where you are administering any medication covertly. So if medication is put in food, for example, and given to someone without their direct knowledge, then that might need a specific power as well. And some of these things are things that as much parents probably do quite routinely, but if somebody is getting any form of paid care, then they'll want to see that the powers are there. So that's just some examples of them. I'm just going to run through quickly before we pause what the costs are, because obviously that's the big issue for people. So legal aid means that provided you're asking for some what we class as welfare powers, so about medical treatment or care, you will get legal aid, which means the vast majority of the work will be paid for. So you'll not be asked to pay for medical reports, court fees, and for your solicitor's work and dealing with the application. Sometimes we'll apply a charge for the preliminary work, and that's because for that initial bit of work, they look at what the adult resources are. So for most of you, your son or daughter's resources. And while they might not have much, if they're still in full-time education, then they kind of come full circle and say, well, mum and dad are still under a duty to support you. So they may look at mum and dad's resources as well. So I'm going to say, please don't worry about that. Please don't try and work it out on your own. I could spend some time telling you what the various limits are financially, but it can be a bit confusing. And we're used to dealing with it. So if you want information about whether or not you would qualify for legal aid, then I could tell you within a few minutes just by asking a few questions what you'll have to pay if anything. And the solicitor does the applications for you. So don't let it put you off. But if you go to a lawyer, please check that they do the work under legal aid, because most of it will be covered, and check if you have to pay for the preliminary work or not. And if you are paying for it, I would not expect a lawyer to charge more than £500. So I'm giving you that as a ballpark figure. If you're quoted thousands of pounds for doing an application, please go somewhere else and get another quote. So I think that's a very brief run through guardianship, and I'll maybe pass back to Tracy and we can see if we've got any questions or if anybody wants to ask anything that hasn't been clear or hasn't been covered.
Okay, thanks, Nicola. We have got a couple of questions, but I'm quite happy if anybody wants to send through any more, or if you want to ask Nicola directly, if you want to put your hand up, and I can let you speak to her directly. Okay. So with the questions that I've got so far, Nicola, there's a few things about cost, not too surprisingly. One person's asking is, what is the income limit for legal aid? Is there a particular figure, or is it very much dependent on circumstances?
Okay, so for the full legal aid, there's no means test at all, no income test at all. So you could be earning £2 million a year and you will still qualify. The bit of work I described at the start, if you are receiving what we call a passport benefit, then it's automatic. So that is income-based employment support allowance, income support, and they'll ignore things like DLA or PIP. Otherwise, the upper limit is £245 a week of disposable income. What they call disposable income includes foods and things like that, so it's not as high as you would think, and around £1,700 in savings. So if you have a job and or have savings of more than 1,700, then you may be charged something for the initial work. But for whoever asked that or anybody else who is concerned about it, I would say we can work it out very quickly. So if you want to contact me through Tracy or contact your own lawyer, they'll be able to tell you what the cost is going to be.
Lovely, thank you. And it was coming down to choosing a solicitor or choosing a lawyer. Claire has asked if all solicitors deal with guardianship. And somebody else, it was Teresa, who had asked, how do you go about choosing a solicitor? Because some people, obviously some solicitors will have expertise in some areas, whether it's house selling or, you know, whatever it happens to be. Other solicitors will have other areas of expertise. How can you test somebody out to see if they're the right person to take your case forward?
And I suppose the two main questions to ask are, do you do this type of work? So do you deal with guardianship applications? And the second big question is, do you do legal aid work? Because there are plenty of solicitors in Scotland that do guardianship and do it under legal aid. So unless you particularly want to use somebody, please don't go to somebody that's going to charge you privately for it. Otherwise, there's no, I suppose, guaranteed way. Best thing is probably to speak to somebody on the phone and see if they feel like a good fit, and if you feel that they understand what you're looking for. You can ask how many guardianship applications they do, or if this is the sort of work that they are involved with. Most of our referrals now are coming from charities, or parents at a school will ask. Sometimes they come from schools, or parents ask other parents, who did you use, what were they like? So word of mouth is the best way. You can contact the Law Society, and that will come up with a list of solicitors in your area that do that type of work. But speak to somebody. If you, like getting any other work done, if you're not sure about them, if they're not answering your calls, if you're not happy with the questions, just go somewhere else. You can change your solicitor as easy as you can change, where you shop for groceries. There's lots of choice out there, so pick somebody that feels right for you and you're confident in.
I think that's something that is really important in workshops that I've done where parents have spoken to me. Very often I think people don't necessarily recognise that they can shop around for solicitors as well, because you are the clients, you've got that power to do that. You don't have to go with the first solicitor that you speak to. Absolutely. Or the one that you've used in the past for whatever reason. You can shop around, and I think that's absolutely right, that other parents and carers can be hugely useful as sources of information about who's appropriate and who's good to deal with, who's the right person in that practice. Because you may well find that there's somebody in the practice who's a bit more approachable, or just actually gets it a little bit more than perhaps somebody else. So it may not even be the solicitor firm, it might actually be an individual within that firm that it's worth speaking to. But yeah, I think it's good to recognise that you do have the power to move around or to change whenever you want to. That's entirely up to you. I think one thing that you're probably going to come on to, Nicola, but is it possible to have power of attorney and guardianship? If you've got power of attorney in respect of somebody, would you still need guardianship, or how would that work?
Usually they're either or. So usually you'll either be guardian or be power of attorney. Technically it's possible to be both. So where someone had appointed you as their attorney, but you didn't have all the powers you needed, so you had to, but by that point they were no longer able to make decisions, so you had to go for guardianship. So it's unusual to have both. Normally it's a fairly direct choice between one or the other.
And you talked a little bit about joint guardians and substitute guardians. Helen has asked, if you have joint guardians or substitute guardians, do they have the ability to make decisions separately, or do they have to agree? Does a decision have to be made jointly if you've got more than one guardian?
So the default position would be that they can make decisions on their own, so they don't have to act together. There are dispute resolution procedures you can go through where two people disagree. It is much better to be appointed as a joint guardian or attorney with someone that you feel you can work with and can come to an agreement with, because where they don't agree, it can become difficult and messy to get decisions made. But normally, if for example, it was consent to a flu jab, normally just one of the guardians would need to consent to that, and the doctor would be, or nurse would be legitimate for them to accept the consent of one.
David has asked, what happens if something happens to the guardian, while the guardianship order is in place and they can't continue with those duties anymore, whether it's illness or emergency or whatever? What actually happens in those circumstances?
So you can notify the public guardian, and it would pass either to the joint guardian to become the only guardian. I mean, you can actually have 3 or 4 joint guardians, but usually 2 is enough. So it passed the joint guardian. If there wasn't a joint guardian, it would pass the substitute guardian. If there was nobody that could act, then the guardianship order would effectively lapse and someone else would have to start the process again. If there's nobody there and somebody needs a guardian, then the local authority would do that, and the social worker would become the guardian for them. But it's why it's a good idea to have some future planning in there, because if you don't, you're starting from scratch, whereas if you have a substitute name, they can step in straight away.
Yeah, it's kind of having that safety net, isn't it? And I think that's something that's so crucial for parents generally around transition planning. It's having that safety net and second guessing and thinking about what might happen in the worst case scenario. Okay, there's a question here from Katrina. She says, "Hi Nicola, we were planning to apply to be guardians for our son, but would also like to have his 2 siblings along with us. Are 4 guardians possible, or would they be substitute guardians?"
It's probably easier to have them as substitute guardians. Technically, you can have more than 2 guardians, but it can be, there tends to be a presumption, if you like, against it, unless there was a very, very good reason to do it. So it would be more normal to say, like, mum and dad will be the guardians, but if one becomes incapable, then one or both of the substitutes will step in.
And is there a minimum age to be a guardian? Especially, and this is thinking about siblings who've been very involved in the care and support of a young person. Is there a minimum age at which they can become guardians?
You can do it from 16. So if the sibling's 16, they could be the guardian. It'll just be a question of whether or not you feel that they've got the maturity and experience to take on that role, given you might be dealing with professionals, social workers, care providers, doctors. But some 16-year-olds may be parents themselves and well able to do that. So it depends on other factors. Can be things like if mum or dad have a progressive illness and aren't likely to be around long, then it might be very sensible to have somebody younger. Most people would probably wait till the children are a bit older just because of the responsibility involved, but you can do it at 16 and sometimes that is appropriate.
Joe has asked, once you've got guardianship in place, how do you go about exercising that? I don't know if this is really a question for you because you're more about getting those powers in place, but how do you go about exercising it once you have it? Do people automatically speak to you about it and check if somebody has guardianship, or is it your responsibility as the guardian to kind of be proactive and let people know that there's a guardianship order in place?
So no, I would normally advise people just to let them know, give you some copies of the guardianship order and make sure they're registered with particular people. So things like the GP is a good idea. They can put it on the emergency care summary so that if you phone NHS 24 or whatever, they can see, so you don't have this nonsense of asking to speak to somebody that isn't going to be able to give you the information. Send it to social work, send it to the school, send it to any care providers that are involved with the person, because they won't automatically be told about it. But in terms of exercising it, you're basically that person for the purposes of it. So if something needs signed, you would sign it for them as guardian, so just your signature and sign under it. If it's medical consent forms, anything like that, you should just be asked to sign them for the person. So to be honest, for most parents, it'll just be doing what they've always done, but just having this piece of paper in the background saying that I've got the legal authority to do it. You have till they're 16, you have this generic parental rights and responsibilities that just let you sign and make decisions. After 16, you would have a bit of paper in the background that did the same thing.
That's great, thank you. Kathleen has asked, what happens if the young person doesn't want a guardian, but parents think they need it? Can the school give reports to support the application? What happens there?
The school can. In those cases, we would normally, you would, if there was a dispute like that, so someone thought they didn't need a guardian, it'd be a good idea for that the adult, the person who was going to be made subject to the order, to have their own representation. So to have either an independent advocate and possibly a solicitor to represent their views and to oppose it. And in that case, the sheriff would look at all the information, look at the doctor's reports, the school reports, what the parents said, and what the person themselves said, and make a decision. The courts have a procedure in that case, rather than a big complicated court case where it'd be stressful for everyone. They tend to appoint someone called a safeguarder, and the safeguarder meets up with everyone, reads all the paperwork, and comes to, if you like, an independent view on what the right thing to do would be, and the court will normally go with that.
I'm guessing this is around issues to do with capacity as well, isn't it? Do you want to say a little bit about capacity? Because I know that's a term that a lot of parents kind of struggle with. It's difficult to know whether your child has capacity or not.
It is difficult. I mean, some cases will be very clear cut, some aren't. But you're looking at whether or not somebody's able to make decisions for themselves and understand the implications of those decisions. So the medical reports go some way to dealing with that. Obviously, other people might have views on it. So you may have an advocate, you may have the school, you may have a social worker with different views. And at the end, if there's a dispute on it, the sheriff would look at it and make that decision. It's difficult because what you're looking at is, can someone make a decision? Can they understand the consequences, and can they safeguard themselves? So for us, it comes up a lot for, I spoke about social media, and where you've got someone who wants to interact with their peers and beyond the various platforms, but is forming inappropriate relationships, sending images with maybe not really understanding what people's motivations might be. And then at that point, sometimes you do need a much more detailed capacity assessment with somebody that can, really try and unpick what somebody understands, whether they can safeguard themselves. And in those cases, they'll tend to perhaps just give you the power for a year and review it and see what's happening. Or give limited powers, or they'll try and adapt it so the person has as much freedom as possible but is still protected. But it's difficult. I don't think we always get it right.
I think, as I understand it, the courts are looking to allow people, young people, as much autonomy, if you like, to be able to make decisions as they can, because that's part of their rights to do that. And as you said, safeguarding the issues, spotting the issues where that's not going to work well, or where that could end up making them vulnerable, and getting somebody to assess where those boundaries lie can be quite a challenge. Yeah. Does that lead you on to, I'm just looking at the time slightly here. Do feel free to carry on sending through your questions, because I'll keep putting them to Nicola as long as we can. But Nicola, does that bring you on to talking about power of attorney? Because how does that differ from guardianship, and where would that fit into the picture?
Okay, so I'll do just a little bit about power of attorney, and then if there's any questions about how it fits in or what might be appropriate, you can deal with that, because lots of people are confused about which one do I need, what's the difference, can I take out a power of attorney? So essentially, a power of attorney is basically something that you sign now to decide who makes decisions for you in the future. So if you the person who is granting the power of attorney is the one who would be my client. They would have to be able to understand what I explained to them, understand the legal document, what it means, and be able to, I say be able to sign it, be able to agree with it. If somebody can't sign, there's procedures to deal with that. But they would have to understand what it was and be happy to grant it. If they can't do that, you can't do a power of attorney, that's off the table, and you're looking at guardianship. So most of our clients that grant powers of attorney do it, mostly it would be mum and dad who would be thinking about a time where they weren't capable anymore. So thinking about if they had a brain injury, a stroke or dementia, do they want to appoint somebody now to make decisions for them in those circumstances? So that's the most common circumstance where we have clients that grant a power of attorney. We occasionally do them for people who have learning disabilities, or quite often people who have been diagnosed with Alzheimer's or dementia, but still have a high level of understanding of their condition and what they want to happen. Where we're doing it for someone, say with a learning disability, we can do a power of attorney that says somebody else can start to manage their money straight away. So if it's a situation where someone needs some support with managing finances, that bit's quite easy. When it comes to welfare powers, so powers about medical care and support and treatment, then that doesn't come into effect until the individual's lost capacity to make those decisions. So you grant the power of attorney and you keep making your own decisions until it comes to a point where you lose capacity. So something has to change in terms of your ability between granting it and it becoming effective. So if you're thinking about a family member who, if you want to be making decisions about their care and support or medical treatment now because you don't think they can, then a power of attorney is not going to work. It would only work if someone understood it just now, understood what they were signing, but you were concerned that at some point in the future they might not. So we often use them for people who have mental health issues, which mean they have fluctuating capacity. So sometimes they can make decisions, sometimes they can. We'll use it for someone with a learning disability where they want some help managing their money just now. They're able to make their own decisions, but they're concerned that in future they might not. So sometimes, for example, if somebody has Down syndrome, there can be a higher instance of early onset dementia. So it can be a good idea for them to sign a power of attorney thinking towards the future. So hopefully that's clear. Is the person that grants it, they have to have capacity at the point they grant it, and the welfare powers will come into force at a point in the future when something changes. We have, they look very like a guardianship order, so if you just looked at them both, they would look almost identical, and they have similar sorts of powers in them. The difference is they're not a court order, you grant it yourself. So that means they're not reviewed, they're unlimited, they last forever unless you change your mind about it. And they're not reviewed routinely, so you won't have an annual review by social work, you won't be asked to put in accounts by the public guardian. You will just be able to exercise it because as soon as something personal, you've asked someone else to look after your affairs and the state doesn't intervene too much in that. Because there are less restrictions or less review mechanisms in there, we have quite strict rules as lawyers on granting a power of attorney, particularly when somebody is vulnerable in some way, whether that be age or disability or capacity. So we have to follow particular guidance, which means we would see the person on their own and do our best to make sure there wasn't any pressure on them and that they fully understand what they were saying. So it's something we recommend everybody thinks about because anybody could lose their ability to make decisions, but where you want to make decisions for somebody now, it might be more appropriate to look at guardianship rather than a power of attorney. if you're doing a power of attorney, we would look again at specific types of powers. So if you were doing it for yourself, we might ask some personal questions, not asking you to disclose information, but asking you to think about what somebody might be able to see. So it's common now for a power of attorney, if you're appointing someone as your attorney to say they can have access to your social media, to online passwords, to emails, access to medical records, social work records, and people may have things in their formal records or on or various email accounts or social media accounts that they don't necessarily want their son or daughter or husband or wife to know about. So we ask people to think about things like that, and to think about things like medical wishes. So if they have particular views about what sort of treatment they might want in particular circumstances, that they record those. For because a power of attorney it's not a court application, it's much cheaper than a guardianship order, which is another attraction for doing it now. You might never need it, but if you do, it saves you having to apply for guardianship at a later date. If you are on a low income, you might get legal aid to do a power of attorney, so explore that first of all. In the same way to do things like your will, you might qualify for legal aid as well. If you don't, we charge £200 plus VAT to do someone's power of attorney. You get the best thing to do is to ask what the cost might be. I'm telling you that not because I think it's a particularly expensive or not expensive, but just to give you a ballpark figure to say if someone's quoting you a price of £600, £700, £1,000 for a power of attorney, unless you particularly want to use them, then maybe think about going elsewhere, because they all look pretty standard and they should all have the same effect. You can do a power of attorney without seeing a solicitor if you visit I think there's a link on the end of the slides. I didn't put the slides up, but if you download them, there's some links at the end, and obviously the Public Guardian website has styles, so it's possible to do it on your own. If you want to do that, have a look. The main issue is a lawyer or a doctor has to certify at the point somebody signs it that they have mental capacity, that they understand what they're signing. And so you may still have a fee to pay if you have to go to a lawyer or a doctor to have that signed. Make sure you're looking at the right thing, because I've seen a lot of people download English powers of attorney, which if you live in Scotland are not going to be effective for you. So yeah, think about look at the cost. There's a fee as well of £81 to register it with the Public Guardian. So that's a fee that goes to a government body rather than to us, and you have to have it registered before you can use it. So because I'm conscious of time, that's a super quick run through powers of attorney. Hopefully I've made the difference clear, but Tracy, you can maybe tell me if there's any questions or anything you think I need to clarify on that, just to help people understand.
No, that's fine. I was just interested in what you said about, if you have the English power of attorney, it's not valid in Scotland. So if you've moved from England to Scotland, or if you're planning on moving from Scotland down to England, and you have these orders in place, can you still use them, or do you have to start the process all over again?
You can normally still use them. So they have various international conventions that let a Scottish guardianship order or power of attorney be recognised in other countries. But what you can't do is use an English one if you actually live in Scotland. So it has to be valid at the point that you set it up. So in the same way, if you downloaded a Canadian one, it wouldn't be much use. But if you just Google Office of Public Guardian, your first hit will be the English one. It's very, very easy to be looking at the wrong information. So you can do it yourself. I'm not suggesting people don't. I just weigh up. You might only be saving a small amount of money and giving yourself a lot of hassle to do it that way. But you can usually move between jurisdictions, and your documents, your wills, your powers of attorney will still be valid, but it's got to be the right one in the first place that you've signed.
So it's another argument really for finding a good solicitor, and just checking that what you think you have, the powers you think you have, are actually valid for what you need them to do. Yeah, if you're in any doubt. We've got a question about if somebody who has power of attorney for a family member and they develop dementia, so they can't continue to act as the attorney, what can happen then to the person who the powers are for if they don't have capacity any longer either?
So in that case, if you'd named a joint or a substitute, it would pass to them. If there's no substitute or joint guardian that can act, then the power of attorney basically falls and you would start a guardianship application in the way we talked about at the start. So good idea if you're doing one. Again, most people will name a partner, a spouse, and then maybe have it pass to their children if you're planning down the generations a little bit. But for power of attorney, always good to have someone if you're a bit younger than you name somewhere, because they're statistically more likely to be there.
And again, it's that kind of forward planning and the safety net. Yeah, so we're getting towards the end of the time. Are there any more questions? Has anyone got any burning questions that they're wanting to ask Nicola at the moment? If you do, send them through in the next couple of minutes. If anything occurs to you after this webinar is finished and you would like me to pass it on and get an answer for you, do please just email me. I think you all have my email address. It's tracy.francis@arcuk.org.uk. Send me an email through and I'll get an answer for you. That's not a problem. Just going to check and see if there's any more questions coming through towards the end there. No, it doesn't look like it, but one person said thank you very much. So thanks, Nicola. I'll echo that. That's been really helpful. One of the things that I would say, as well as talking to other parents, talking to talk to two or three different solicitors, make sure you get the right person. The carers organisations can be really good sources of information as well. The one that I know best personally is Vocal in Edinburgh, but there are other carers organisations around the country, and they very often have ideas about local solicitors where you are, who are experienced at working with this kind of thing, and who will be able to give you the information and advice that you probably need. The other thing to draw to your attention, we talked about this website last week. It's the contact website called Talking About Tomorrow. If you Google Talking About Tomorrow, it will come up, and it's written from a parent's point of view, and it covers just about every aspect of transition planning that you could think of, but legal matters is in there as well. So it will talk you through guardianship, powers of attorney, and also wills and trusts, because that's something that we haven't talked about today, but it's a really important thing to have at the back of your mind. Not necessarily right now when you're young people, if you're at the stage where your young people are leaving school, but it's really important as they move on into adulthood to make sure that you get those kind of aspects tied up. And you know, it's about the safety net. It's about safeguarding and making sure what you want to happen and what your young person wants to happen is what's most likely to be able to be in place going forward. So I recommend the Talking About Tomorrow website as well to have a look at. So the last thing is just to say again, thank you to Nicola for coming along and for sharing that with us, Nicola. That was really helpful. We've got another session next Wednesday, and that one is on developing independent living skills. It's how to encourage your young person and support them to develop independent living skills. And what are independent living skills? What do they need? What sorts of things should they be focusing on? Because very often those are the things that kind of get a little bit missed out in education. They get a little bit missed out by people who are working with just one aspect of a young person's life. But actually, they're the bits they're the glue that holds everything else together for many young people. So we have people from Differabled. We've got Debbie Best and Heather Wright joining us next Wednesday afternoon. So if you haven't already signed up for that, do go to the ARC Scotland, the Scottish Transitions Forum website, and you'll be able to sign up to that webinar as well. So I'm just going to say thank you very much for joining us. Hope you found it useful, and we hope to see you again in one of the webinars later on in the series. Thank you.
Thank
Bye.
you.